Over the next several lessons, we'll explore Roman law, the great body of Roman law, the most influential legal system in all of human history. And we want to explore its conceptual foundations. What is the basis of Roman law? What are its concepts of justice? How does it fit into the conversations that we've been having about the nature of law and justice? And we'll explore these questions through a variety of approaches. We'll look at the meaning of status, and we'll look at the meaning of rights, briefly, in the great body of Roman law. Now, when we say Roman law, we can mean different things, because Roman civilization is a civilization that exists across more than a millennium of history. The foundation of the city in 753, the establishment of the Republic in 509 BC, the establishment of monarchy under Julius Caesar and his successor Augustus, all the way down to the fall of the Roman Empire in the 5th century AD. So what do we mean by Roman law? By Roman law, we focus principally on what we can call classical Roman law. Classical Roman law is the Roman law that took shape in the period of the early monarchy, from the age of Augustus at the end of the 1st century BC, the early 1st century AD, down to the age of the early 3rd century AD. This period, say from 1 AD to about 235 AD, is the classical period of Roman law. Roman law existed before this, all the way back to the 12 Tables, the first written law code at Rome. Roman law developed in the late Republican period. It became more complex, more sophisticated. It adapted to the transformations in Roman society. As an agricultural people became a great commercial empire, Roman law developed with Roman society and the Roman economy to adapt to the new needs of a changing society. The age of Cicero was a great age of Roman legal thought, but this age is mostly lost to us. We only know Roman law in depth in the classical period, and that's because the writings of the classical jurists survive. And they survive because they were codified and preserved in a late Roman codification known as the Justinianic Code. The Justinianic compilation is made by the great late Roman emperor Justinian, who rules in the 6th century AD, from 527 to 565, an extraordinary long and tumultuous reign that also saw extraordinary activity and renaissance in Rome. Of course, Justinian lived in Byzantium, New Rome, Constantinople. But he considered himself the emperor of Rome and the ruler of a Roman empire just as much as Augustus did. And Justinian undertook a great act of compiling and systematizing and organizing and digesting Roman law. And during his reign, he would issue a compilation that synthesized hundreds of years of legal tradition into an orderly and easily grasped single whole. Justinian issued 3 texts that would synthesize the great body of Roman law. The Institutes, which were a short textbook and introduction to Roman law. The Digest, which was a synthesis of all of the theoretical writings of the classical Roman jurists that took some 3 million words and boiled it down into a manageable compilation. And the Digest is our central text for Roman legal theory. And thirdly, a book called the Codex, which was a collection of rulings and statutes that updated Roman law after the compilations of the jurists. And so Justinian's 3-part compilation represents the single most important source we have for understanding the foundations of Roman law. And when we say Roman law held this or that, we're talking principally about the Roman law under the age of the emperors, the first 2.5 centuries of the Common Era.